Wait a minute. Have I not been live this whole time? Did I screw something? Because I'm like, where are the comments? I just realized it says upcoming. Oh, here we go. This is bizarre. Well, hello everybody, and welcome back to Buckle Up. It's the Law with your host, the DUI Guy Plus. I've been talking to myself apparently for the last 5 or 6 minutes. I thought I went live, but I guess I just started the broadcast and now I'm live. So this is good. I haven't really covered much. What I was starting to say, there we go. See, now the comments are pouring in. I'm like, I've been talking to myself for the last 5, 6 minutes. It's okay. I'll just give you the TLDR version. We're back in Karen Reed. We're back in the courtroom. Sorry I missed yesterday. It was a very busy day. As you all know, I'm also running a law firm. So sometimes those two obviously don't work together very well. But I've been playing catch up. I've been catching up on YouTube. I've been catching up on Twitter/X. And I've been catching up on all the details that have been going on in this case. Now, I've missed a lot. I know there's about 4 hours of footage that I missed yesterday. And we're still waiting on NBC 10 Boston. As you can see, the okay, is this better? We always have volume issues. People are saying volume is very low. This should not be low. It should be like either it's too loud or it's too quiet. I don't have like a middle ground, which is really bizarre. Is this better? Okay, volume is good now. Okay. Good gravy. One day it's going to be fixed, and it's going to be fixed for good, okay? Because this is ridiculous. There's only so much Larry can tolerate. You know what I'm saying? Um, okay. All right. Yeah, my chat is on a delay. My chat is on a delay because you have to um I have to make sure to keep the trolls at bay. You know what I'm saying? Okay, so we're back with the Karen Reed case. For some of you who have not been following this case and you don't know what this is about, let me fill you in very quickly. Karen Reed is accused of murder. She has allegedly hit her boyfriend with her SUV in January of 2022, I think. January, February 2022. She has been accused of murder. She's been prosecuted. A trial started, a trial ended in a mistrial, despite the fact that there is an interview. By the way, the interview is coming out today. The interview is coming out today that one of the jurors, he has already been interviewed by Turtle Boy, and now he is going to be interviewed by NBC 10, I think, or one of the news stations. One of the news stations are going, you're kidding. Okay, I'm afraid I'm either going to burst your eardrums or I'm going to be too quiet. I can't find my middle ground, folks. I'm sorry. Hopefully this works better. Still low. All right, this is the maximum. This is the absolute possible maximum volume that I can provide. And watch, now the comments are going to come in saying that I'm busting everyone's eardrums. I can't go higher than this. This is the maximum that my system allows. Okay? All right. All right. Leave it there. Watch. Somebody's going to come in and Larry, you're killing me. You're bursting my eardrums. All right. Okay. Okay. Now everyone's saying it's perfect. Awesome. All right. Oh, it sucks when you have everything is different and you're trying to make it work. But hopefully we can move on now. Okay. So Karen Reed they're starting trial number 2 on April the 1st, allegedly. Allegedly. We're waiting for Alan Jackson and the team to come back from federal court because they had federal court this morning. Thank you very much, Fallen Hero, for the dono, which is another thing. Since I don't use StreamYard anymore, I can't highlight your super chats. I have to figure out how to use it in OBS. If you have comments and suggestions on how I can highlight comments when I'm using OBS, I will love you forever. So please reach out to me if you know. The only way I was able to find on how to highlight comments during live streams is by going into like some sort of an extension that I have to download. And I'm like, no, I don't want to get into all of that. That seems a little convoluted. But if I have to, I'll do that. StreamYard is very dumb. The quality of the video is diluted because I have to go through their servers, whereas OBS has much better servers, much higher quality. And especially with such a beautiful studio, I want to highlight, what's the point of having like a good camera and good lighting and a good background if all you're going to do is dilute the value when you are, streaming and whatnot. So anyway, back to the point, back to Karen Reed. So Karen Reed, there was a hearing yesterday, lasted about 4 hours. I caught just a couple of minutes of it. Like I said, I was in meetings all day, so I was not able to catch all of it. I caught just a very, very brief glimpse, but I did catch an ending to one of the arguments that Alessi was making, and Judge Bev allegedly took it under advisement, took it under consideration, is going to rule on it. Chat, please correct me if I'm wrong, but as I understand, there is absolutely no rulings from Auntie Bev at this point. Is that correct? Auntie Bev has not ruled on a single issue. She is still listening to arguments before she is ruling on any of the motions. I haven't heard her make a ruling yet. And yeah, people were talking about the lamp. I decided to get rid of the lamp. So we're not going to have the lamp anymore. Correct. Okay, so we don't have any rulings. I want to talk about something very, very important. I want to talk about the letter that was released yesterday by Canton PD, allegedly regarding the federal investigation. And I want to ask some questions, okay? So let's share it first. Here's the letter. To all media outlets from Helena Rafferty, Chief of Police. It's dated yesterday's date, March 4, 2025, about the federal investigation. And I quote, reading from the letter. I recently spoke to and was informed by the U.S. Attorney's Office that all aspects, in capital letters, of the federal investigation initiated by her predecessor and related to the death of John O'Keefe, have been completed. The investigation is no longer active and will be closed. Due to ethical limitations, I cannot comment further. End of release. Okay, so this came from the FBI, right? Wrong. Okay, it at least came from the United States Attorney's Office, right? Wrong again. Where did it come from? There is no header. As you can see, there's nothing at the top. But at the bottom, we have the giveaway. Where did it come from? www.cantonpolice.com. And we saw in the beginning from Rafferty, Chief of Police, right? Okay, so let's break it down. First of all, I want to break down the language of this letter and this release, I should say, and why I think it's bogus. First of all, if the Federal Bureau of Investigation, and this is what I tweeted yesterday, or the United States Attorney's Office are going to conclude an investigation, you would anticipate that they're going to make a public statement themselves. It's not going to be hearsay from the people being investigated. Canton PD is in the crosshairs. They're under fire. There's allegations of corruption. There are allegations of corruption. There is alleged abuse of power, abuse of process, botched investigation, planting of evidence, etc., 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 hiding of evidence. And now, so let's break down the statement. Okay, let's first break it down. I recently spoke to how recently? Because there is a video out there, and I can find it if you guys want to see it, but there's no need. It's just Karen Reed walking out of the courthouse, being confronted by a reporter, and the reporter asks her, "Are you aware of the Federal Bureau of Investigations investigation?" And she said, "Yes, we have a letter signed and dated February 19th, I believe is the date, that the investigation is ongoing." Or January 31st, something like that. I can't remember the exact date, but like weeks before this letter was drafted. Weeks. Mere weeks, almost days. And now all of a sudden they're going to be like, "Okay, we're done. Never mind. We changed our mind. We changed our mind. We don't want this anymore." Excuse me? So this is Chief of Police Helena Rafferty, who has a personal vested interest for the investigation to be concluded. So it's a biased speaker with a vested interest. You know what we call those in court? Unreliable witnesses. Witnesses who cannot be trusted. It's like putting my client's mother on the stand who's going to say, "Yes, I was in the car and my son didn't do anything." My kids would never. My children would never commit a crime. My children would have never done this. Okay? So, it starts out. I recently spoke to. How recently? Yesterday recently? You know, there's an argument to be made that a month ago is also recently. How recently? It's vague. It's intentionally vague because they're going to paddle back at some point later on. Because the defense has a letter saying it's still ongoing. So which is it? Is it the letter from the feds or the AUSA, the Assistant U.S. Attorney, that we trust? Or do we trust Canton PD, the ones who are being investigated, the biased witness, as I keep calling them? Okay, so recently. We don't know how recent. An hour, a day, a week, a month. There, like I said, 6 weeks could also be recently. In the court of law, things move pretty slowly. As you can see, her previous trial concluded in June, and it's only going to start up in April. 10 months is a long time. So in the span of 10 months, a whole month, month and a half could still be recently. I recently spoke to and was informed. Okay, so you received information by the U.S. Attorney's Office. Pause right there. By the U.S. Attorney's Office. Whomst in the U.S. Attorney's Office did you speak to? John, Jackie, Helen of Troy, you know, Zeus the Almighty? Like, give us a name. Who did you talk to? It is intentionally omitted because there are a lot of assistant U.S. attorneys, especially in such a big office in Massachusetts. There could be dozens, there could be over 100 AUSAs working on this case. So maybe she cherry-picked to speak to someone who has no knowledge of this, who just heard it on the grapevine. So now you see it's hearsay stacked upon potential other hearsay, and we're getting it from another hearsay source. There is no direct link between the person, let's say, or the team or the group or whatever that are doing the investigation, conducting the investigation, saying, releasing an official statement saying, we've investigated, we concluded nothing was wrong, we're done, or whatever. Or the opposite, we concluded, we found issues, and we will act in accordance with our suspicions and what our investigation has unearthed. Okay? Let's keep going. That all aspects, now it's in capital letters. Why is it in capital letters? Are you trying to emphasize this one point, Ms. Rafferty? All aspects, or Chief Rafferty, I can't call you Chief. You're just, I don't trust you. Ms. You're staying as Ms. Ms. Rafferty, that all aspects of the federal investigation, all aspects. All right, we'll just leave that for now. Of the federal investigation initiated by her predecessor. Okay, now at least we know the sex of the AUSA, of the U.S. attorney that she spoke with. It's a female. Her predecessor. So whoever started the investigation related to the death of John O'Keefe have been completed. Have been completed. And this is right here, this is where everybody is getting the ick, as they say, to put it mildly. The investigation is no longer active and will be closed. It's not closed, okay? This is very, very important. She did not say, I spoke to her, and she said the investigation is completed and is officially closed. At which point I would say, okay, maybe, still fishy, still don't trust the speaker, hearsay upon hearsay upon hearsay. Who did she talk? Give us a name. I mean, it narrows it down, like I said, to all the female AUSAs by virtue of the her modifier. And will be closed. So it's not closed yet. Then why are you releasing a statement? Okay, so you've completed the investigation. All you have told us is that we have all the evidence. We have all the evidence. We don't need to investigate any further. That's what you're telling us, is that they have all the evidence. They don't need to investigate further. But they haven't reached a conclusion yet. This is literally what this letter is saying. I have not yet reached a conclusion. It's not closed yet. It will be closed. It's right there in the letter. The investigation is no longer active and will be closed. But it's not closed yet. And this is the fishiest part. This is the fishiest part. Due to ethical limitations, I cannot comment further. So that means there is more to be said. The investigation is done. They don't need any more evidence. They are making a decision as to what to do, and it will be closed at some point in the future. A week from now, a month from now, 6 months from now, and they will determine if there are any arrests to be made, if there are any further interrogations that they need to do, if they need to question any of the witnesses or potential witnesses or what have you. So if anything, what we have learned from this letter is that the investigation is concluded and the FBI is still going to take action. It is not closed yet. So thank you for telling us. You see, when you break things down, like on the surface, if you read it really fast, it's like, oh, it's all over. But when you start to analyze the language, the choice of words made by Canton PD, you're getting a completely different picture. And that's what lawyer work is all about. So, let me translate. Let me translate this letter to human language. 2, everyone everywhere, because I am tired of being in the crosshairs. From Helena Rafferty, Chief of Police, dated March 4th, 2025, about the federal investigation into the death of John O'Keefe. I have been in conversations with at least one unknown person that I refuse to release the name of at the U.S. Attorney's Office. I am not sure whether or not they're involved in the investigation or not, but based on my brief interaction with them, I have decided to use that person as my scapegoat because I'm tired of the BS. Leave me alone. That the federal investigation has been concluded. They have all the evidence that they need. They do not need to investigate. Keyword, investigate. Further. However, a report may follow. I just don't want to tell you guys that. Arrests may follow. I just don't want to tell you guys that. The federal investigation is still ongoing. It's going to be closed at some point. It's just not closed yet. But I want you to believe that it's over. That is why I'm using fishy language. And because I am a shyster and not to be trusted, I cannot comment further. There you go. Now it's translated. Now you know exactly what she said. So, look, I wouldn't trust this woman as far as I can throw her. I don't trust anything coming out of her mouth, like I said, because she is biased. She has a personal vested interest in making sure that they be left alone, because they have probably received a lot of heat because of this, and rightfully so. When you intentionally botch an investigation and you plant evidence, I mean, come on. It doesn't get dirtier than that, folks. Murder? If it was like a drug case and you planted some drugs, I'd be like, okay, fine, whatever. We'll deal with it. That happens all the time. But it's so heinous. It's so openly heinous. And it's very hard for me. I can't be a fence sitter. Okay? That's just not in my personality. I know a lot of people give me flack on YouTube and X sometimes that like, oh, Larry, I just can't listen to Larry. Larry is so biased. I disagree. I speak the truth. I see it. I feel it. I have my attorney instincts, I have my legal knowledge, I have my legal experience, and I'm sharing with you when things don't make sense, you're going to get the most unfiltered version of events from me. I know there's some law tubers who refuse to take a stance and they try to kind of be in the middle, and that's fine. You're more than welcome to go watch them. That's why we have choices. But the people who come to my channel, the people who are going to listen to me talk about cases and facts of a case, you're going to hear the opinion of a trial lawyer who has litigated cases, who has experience with evidence, who has received guilty verdicts, who has received not guilty verdicts, who has received not effing guilty verdicts. If you all don't know what that is, it's a verdict less than 15 minutes. Like jury goes out, they come back in within 4, 5, 6 minutes and vote not guilty because it's so simple and they're wondering why the prosecutor brought the case in the first place. I have 3 of those under my belt. Not tooting my own horn, just stating facts. And the most important piece about all of this, the most important piece is, in my humble opinion, this is just my opinion, if after everything that you have seen in the trial, after you've listened to the juror who was in the trial, which in all fairness, I have not heard everything they had to say, but I read the snippets, the Cliff's Notes, you still have a doubt about her innocence, about Karen Read's innocence. It's one of 2 things. One, you're a government agent, you support the government, and you will stand by the government no matter what, which is fine. You're entitled to your opinion, just like I'm entitled to mine. And we can fight about it all day long. Or 2, you just maybe are missing something. And that's okay too. It's okay to not grasp, maybe you have a limited understanding of something and you're never going to admit it, and that's fine. I'm not faulting you. To me, the way that I sit before you today, looking at all of the evidence, looking at all of the facts, looking at what a juror who listened to every aspect of this trial literally say, we concluded there is no way the vehicle made contact with with John O'Keefe. There's no way that Karen Read's vehicle made contact with John O'Keefe's body. It's just not possible. They had, teachers, engineers, scientists, physicists, a few other people over there in the jury pool deliberating over this case, and they all concluded the same thing unanimously. We just never got a chance to hear it because Auntie Bev never polled them. So that's where I stand, and that's where I will continue to stand until I see something different, which I don't anticipate is going to happen. And I'm really looking forward to the second trial because I want to see, I want to hear, I want to know what this new jury is going to decide and how it's going to unfold. And if the feds are going to be initiating arrests. I guarantee right now as we sit here today, this is what brings me comfort, at least with respect to this case. At least since the trial started, and probably well before that, the McAlberts have been crapping their pants every day. I doubt they're able to sleep at night very comfortably. I highly doubt that they're able to, and I'm referring to the Alberts and the McCabe's, the McAlberts as we call them. I highly doubt that they have been able to get 1 minute of quality sleep because they know the gavel is still going to come down. The gauntlet is, I'm mixing my metaphors. I always do this. My girlfriend always calls me out on this. The truth will come to light. And that's what we're here for. This is what we've been waiting. More and more and more eyeballs have been coming on to this case from all over the world. I am so amazed. How many countries? Right now, shout out in the chat. I want you guys to tell me, what country are you watching from? I guarantee we're going to count at least 10 countries with only 7, what is it? We have less than 800 people here. My girlfriend does not have a name. We've talked about this. She is the future Mrs. Larry Foreman. Okay, we got the UK, Iceland, California. That's so USA, Ireland, Australia, Canada, South Africa, Sweden, Togo, Netherlands. There we go. Already 10. Already 10 countries. Look at that. There's a reason for that, because this case is absolutely mind-boggling. And it's entertaining. I mean, there's nothing you can, there's no ands, ifs, or buts about it. It's entertaining to see how corrupt a jurisdiction can be. Hey, RJ Medic. Welcome back to the channel. RJ Medic says, we love you. I love you too, brother. Thanks so much. I wish I could highlight comments. I need your help to figure out how to highlight comments. Oh, we got Nick Stero in the chat. What's up, Nick? Let me know if you want to come on. I'll have to figure out how to even put you on. Honestly, wait a minute. Do I even know how to do that? I just realized I may have to like create something somewhere. I may have to like create a Zoom. Yeah, I haven't tried having guests with OBS yet. Remember that Martha Stewart went public that the feds told her they didn't investigate her. Weeks later, she was arrested. Bingo. Look at that. Exactly, Nick. Exactly. Martha Stewart went public. She said, hey, the feds didn't investigate me. I'm all good. Weeks later, boom, handcuffs. Fallen Hero, I shouted you out. Thank you so much. And RJ Medic, thank you for being a member for 1 month. And Subi Su, wow, we hit the 2-year mark already. Damn, where has the time flown? Yeah, billboards are garbage. Any lawyer who still advertises using billboards is pissing money away. Unless you have like millions and millions and millions of dollars to spend on advertising, sure, get some billboards. Otherwise, billboards are completely useless. Media. Electronic media, that's where it's at. Hey, Mrs. K. Grift. We're still waiting on the court. We are still waiting on the court. They said they were going to start at 11, but it's not going to start at 11 because we don't know when the federal hearing this morning is going to conclude. Does anybody know what happened in federal court this morning? Has anybody been following either Turtle Boy or I don't know if the Glare was there or Tom's CPU? Shout out to all of you guys over there. Mimi Love Good Law says, I love watching how far you've come. Now, Chandler, and you're so happy. Aw, thank you. And they changed it to noon. They changed it to noon, did they? Okay. Well, that's all right. Here's what we can do. Since we have not watched the... Since we have not watched the hearing yesterday, we can do that. Nick is asking for an invite. Oh, yeah. If Mr. Frosted Tips sends an invite, I will come on. Okay. Well, you know what? I'm going to have to learn eventually anyway. So let's give this a shot. Let's see if I can get Nick Stero on here. What's up, Shizzy? In OBS, how do I do this? Let's see. I might have to send you... Oh, I know how I can do this. I'm going to get creative here. You ready? we're going to take this link. All right, Nick, get ready to open up your inbox on Twitter. I'm about to send you a link. Here we go. So that's the link. And let me know once you have clicked on it and joined. And I'm going to have to create a new layout. This is going to be with one guest. Okay. You're going to see a black screen for a few seconds, so please, I need like background music while I do this. Okay, now I'm back. Okay. The only problem is I don't know how I'm going to be able to do a double window capture. When the hearing starts. I may have to kick you out when the hearing starts. Still waiting on you, Nick. But so far, I think this is going to work. I think this is going to work. Eventually, I would be able to like transfer it to Zoom. Hey, Gracie. No, I use OBS. Just waiting on Nick to get his... He's probably getting situated, getting his microphone and everything. So in the meantime, we're just going to do this. This is what I love about OBS. This is what I love about OBS. It is so easy to like, I can change, look, I can do this. And then if I want to change the layout, and then boom, and I can transfer very easily if I want to create a new layout. It's beautiful. I love OBS so much better than StreamYard. It has so much more functionality, so many more options. Speak of the devil. There he is. Admit. Hey, Nick. Let's go ahead and make you bigger. Look at that. Look at that. Look at that. There we go. Can you hear me, Nick? Hello, he says. Well, whenever you're ready to talk, my friend, I think we should be able to hear you. I just muted my microphone in the video in that platform so that I can be here. I can hear noises, so we'll wait if he's going to say something. Move that up a little. Move me down. There he is.
Okay. I can't see you. I'm in picture.
You're not.
But
Can you hear me?
Actually see anything here.
Can you hear me though, Nick? He cannot hear me. Okay, let me try turning on the microphone. Can you hear me, Nick? Nick, can you hear me?
I'm not sure if say something more because I'm not sure I can hear you.
I tried turning my microphone on over there.
Yeah, I can hear you.
Okay,
I can hear you.
you will not be able to see me, but
Mm?
you I, at least you can hear me.
At least I can hear you. At least I can hear you. Ah, that was a very, very interesting email/letter that really didn't tell us anything.
What did you
Because,
think of it?
well, first of all, it's second-hand information, and somebody unknown at the feds told this, what's her name, Jafferty or whatever's, that, oh, we're done. But I want to see that in a court document before I believe it,
Right.
but from the feds themselves, because it's the wording of it. It's weird. It's very evasive. Like she wants to say something, she doesn't. She can't back up properly. That is my take from it. And I read tens of thousands of documents. I mean, I spent 3 years as a documents analyst in the European Parliament. And, you know, when you do something long enough, that much, you get this BS meter in your spine. And this just, nah, there's something wrong here.
Yeah. Yeah, no, I completely agree with you. The thing is, especially in the United States, I like how you said the key word that you said, Nick, was I want something from the court. Why did you say it like that? I want something from the court. Why court?
But because then you have the acknowledgement, then even if it is from Judge Bev, yes, I have received this email. I have concluded that the information here is correct. Then you have then all of a sudden you go from somebody just say transferring information to somebody. Okay, now there's transfer of information that brings a legality to it. And an email from a cop, I don't know if emails from cop generally is allowed into evidence. I don't think it is. It just doesn't make sense because now, of course, if I remember correctly, yesterday Brennan said something to that effect, but nobody actually shows that document. And it is more of this, unless it's a sworn affidavit.
Right. Right.
You risk nothing without, if you don't, I mean, have your signature to it, your actual signature, that under the penalty of perjury, this is the information I will relay. Without that, it's just gossip.
Right. Exactly. It's just gossip. It is. There we go. It's just hearsay stacked upon hearsay, and at the end of the day, who is the speaker? The speaker is the entity being investigated, who has a vested interest for the investigation to be concluded.
Yeah.
Yeah.
Feds can lie. I gave you an example. Martha Stewart went public. I'm not being investigated by the feds. They told me. And weeks later, she was arrested. I mean, I think it's common knowledge that cops can lie. Well, surprise, so can feds. I mean, yeah. So if it turns out to be true, okay, but why then not put it into an affidavit? I Yeah, it's within all the things with this damn case. Everything is brought forward with innuendos, with somebody says something. And why is it so hard to have a clean trial? I I need it explained to me because you covered a lot. Well, you are of course a practicing defense attorney. I've covered a bunch of trials here on YouTube. I've been practicing labor law for over 30 years. It Why can't it just be clean? I Yeah.
The $1 million question, Nick.
Mm,
Why do we have to have corruption,
mm.
Nicholas?
Well, corruption is about power, and power corrupts. That's eh, before we have had writing as a species, we had corruption. I can guarantee it, because as soon as somebody gets power for long enough, there will be corruption in one way or form.
I
So
completely agree.
yeah, but then again, that's why you have this the absolute most beautiful document in the entire world, the Constitution, because your founding fathers knew this. So they said, "Oh, let's put together this beautiful document that will withstand the test of time." And it does, somewhat, with some hiccups here and there, but it is the best it's the best document in history for any country. I wish we had it, but we don't.
Yeah, a lot of countries don't.
Hmm. Sorry. But other than that, how are you doing, Larry? How's the new house?
Me? Oh, great, great. Thanks for asking.
Mm.
We've been here for about 2.5 months now. It's great. We
Oh,
absolutely love it. There's so much space, and we're hopefully finalizing the adoption for our new kitty this week.
oh, oh. Yeah, cats are great. Cats are great. I have my Mr. Jingles here somewhere.
Oh,
Ah, and yeah. Well, once you get a cat, you stop owning stuff. You're just lending it from your cat. That's your cat allows you to use it as long as you feed it and pet it, and yeah, that's the. Uh, uh, so, oh, what else? What else? Yeah, Massachusetts Supreme Court had an oral argument this morning. I don't know if it's still up or if they just cut the feed once they were done.
hmm.
It was about search warrant, one of these weird search warrants. If a specific situation arises, this search warrant you can apply this search warrant.
Mhm.
And apparently the cop, okay, this specific situation didn't occur, but I'm going in there anyway.
Mhm.
So, and this is now up in the Massachusetts Supreme Court, where the state argues, well, it's, yeah.
Exigent circumstances, or what? What is the state arguing? Why was the cop allowed to enter the residence without a search warrant?
Well, the claim from the state is that he had a search warrant, it just didn't apply correctly unless you read all in the affidavits leading up to it. But
Mhm.
then all of a sudden you still have the magistrate's decision. It's not enough. Only under these specific circumstances,
Yeah.
then you can go in. those specific circumstances did not arise, he went in anyway. And the argument from the state is, well, if the judge heard this new circumstance, which prompted him to go in, the judge would have approved it. And I'm sitting there, say, what now? No, you need a new search warrant for. Yeah, it was remarkable, but it was so fun because with the Karen Reed case is in Massachusetts, to hear how is the Supreme Court in Massachusetts work, and oh my God, they really, really hammered down on both state and defense, telling them, give us proper reasons to rule upon. And that was really, really fun to listen to. Really, really fun. I enjoy listening in on appeals court the few times you can, and especially state Supreme Courts, because it gives you an inkling on what might happen if one of the cases you follow.
Sure.
What will happen if somebody gets convicted and it goes up to state Supreme Court.
And chat, this is the kind of stuff that only lawyers can get excited over. I promise you would be bored to tears. You would be bored to sleep. But Nick and I would be like, oh, and then what happened? Tell me what happened next, and what was the argument? And what did the prosecution argue? And what were the arguments raised on appeal? And what were the judges asking questions? What kind of questions did they, like, we get off on this stuff. Only a lawyer can actually enjoy this dry, boring, absolutely, Nick. I'm 100% with you.
Yeah. What was fun, most fun was neither the state or the defense got, I think the state got like 10 words in before the judges went on, and same with the defense. So that's a bit unusual. And often it is because we don't trust. Not trust is not the right word. Often the judges see problems with your written submissions, so they hammer you with questions.
Yeah.
So that part was interesting because neither the state or the defense really got much out of what they might have wanted to, because the judges really, really hammer down. Because one of the judges said to the state, if we rule in your favor on this, how is this not a blank slate search warrant? And that kind of stumped the state. Because if it's up to the cop, even without a proper search warrant, to still enter the house to retrieve some kind of evidence they believe is there, well, then why do you need search warrants?
Right. Exactly.
So that was really, really interesting. But I agree, it's almost only lawyers and the most avid law nerds who enjoys it.
We have a lot of those in the chat, by the way. I really did underestimate my own chat. I'm certain that we have a lot of people who would enjoy that kind of stuff. And people were asking, and I don't want to, I mean, I know the answer to this, but where are you from? What do you practice? And what do you do?
Okay. Hi, I'm Nick. I do labor law in Sweden. I've been doing labor law for over 30 years. I am contracted to a specific union, so I represent workers or entire workplaces in negotiations, either again both with and against the employer if situations occur. And also, my specialty has gone more into safety measures on the workplace. So if somebody gets injured in a workplace, but it does not arise to a criminal matter, then me as from the union, I can step in and help the injured party. So that is what I do. Other than that, I am snarky on YouTube.
What's funny is that was it last year? Yeah, it was last year. Was it last year or the year before? Because I traveled to Europe in 2023 and
Yeah.
2024. We missed each other. There was one time when you were traveling to the US. Were you in
Yeah.
Tennessee?
Yeah. I was in Tennessee in August. I traveled from Texas to Detroit, from
Uh-huh.
Houston to Detroit by car, and I passed through Tennessee. And I believe you left the day before
Yes.
for Europe, the day before I left for the United States.
Yeah, we
And it was,
literally did this. I went to Europe and you came to the United States in like in the same week or something like that.
yeah.
Yeah.
And
Oh, so unfortunate.
yeah, I'm coming back to the States, by the
Yeah?
way, this in September. But this time I'm going to Utah for 2 weeks. I'm meeting up with Legal Vice's family and Danian, and going to visit Jeff, of course, in Utah. And then I'm traveling down to Miami to meet up with Steve Gosney and also with Val Friedman. Val Friedman is the attorney who won against CNN a few months ago,
Oh,
a
really?
multi-million-dollar defamation lawsuit.
I heard about that. You're going to
Yeah,
meet him in person.
yeah.
That is
So
awesome.
that's going to be so amazing. And one of the other cases he has on his table, which I'm going to cover going forward,
Mhm.
it is the Let's Go Brandon meme coin lawsuit against NASCAR.
Was that a rug
Just an,
pull?
no, there is a lawsuit, Let's Go Brandon meme coin, that was supposed to go public with the help of NASCAR, and then NASCAR pulled out with some interesting commentary to it. So they are suing NASCAR. Oh, you mean rug pull as I don't know
The,
the definition of
it's
rug
it's
pull.
when it's when they launch a meme coin. Like what's her name? Talk to a girl or whatever. The Hawk
Yeah.
to a girl, whatever. Haley Welch, I think is her name.
Mm.
She launched a coin and said, "Hey, everybody, invest in this." And then 15 minutes later, after there were millions and millions of dollars from all these people poured into this account, if you will, this coin,
Mm.
she
Ah, okay.
yanked and
Mm.
stole a bunch of money from people, and then the coin just crashed, obviously.
Yeah. No,
That's
this
not
is
a
not because NASCAR pulled out of their deal with this meme coin and spoke badly about the meme coin, so it lost value before it became public.
Oh, so it's like almost like a reverse rug pull kind of sort
Yeah.
of the
Yeah.
creators. The ones who are going to launch it are the ones who got scammed, not the
Yeah.
people who invested in it later on. Okay.
Yeah.
I kind of like that better, not going to lie.
Mm.
Uh,
Yeah.
because
I mean,
those rug pulls are like a dime a dozen these days, it feels like.
yeah,
Like
they are.
any streamer that like starts one of these, it's just immediately, within 15 30 minutes, all that money is gone.
Oh yeah. Oh yeah. I mean, I'm not a fan of uh, these. I mean, I do have half a Bitcoin somewhere, or something of the sort, or a quarter of a Bitcoin somewhere on one of my old devices from like 15 years ago. But other than that, I kind of like cash. I'm a cash person.
You're such a boomer. You're like me.
Yeah, I
You're
know.
like me.
I'm old. I'm old. I'm old.
I like stuff and I like cash because I know that like I have a house. I can feel it. I can touch it. But I me personally, just between you and me, chat, look away. But to turn your headphones off. I do invest in cryptocurrency, but I've learned the hard way. I've lost over $100,000. This is not an exaggeration. Over $100,000 in crypto. I have since made it all back, minus maybe like $500, which is insane to think about, because the market bounced back. Like I kept sitting on. I waited 3 years. I waited like 3.5 years for my moment, and when the crypto finally shot back up, I didn't make a profit yet. I made all of my money back. I am almost back to zero. I'm still like this much in the red,
Mm.
and I'm about to be in the black, but I've learned. I've learned the hard way. Crypto is not something you like hold on to. Crypto is something that if you're gonna play, you better know. You
Yeah.
better know like the when it is to get in, when it is to get out, which
Yeah.
ones to bet on, and
Mm.
it becomes an instinct. And sometimes you're right, sometimes you're wrong. Don't put all your eggs in
Mm.
one basket, just like you do in the stock market. But it's fun. It's fun. It gives me an adrenaline rush, every once in a while. I
Mm.
like I said, I'm very lucky that I was able because a lot of people lost their money and they may never be able to get it back.
Mm.
I've been studying this game for about 5 years, at
Mm.
least 5 years. But
Yeah. I think.
I
Yeah.
was one of the early investors. I don't know if I ever told this on stream, by the way, Nick. I bought 35,000 Dogecoin when they were worth nothing. I bought
Mm.
35,000 Dogecoin for like $20.
Mm.
And back in 2013 in December, like the month it was launched, because I wanted to buy Bitcoin, but I didn't have $200 to rub together. I was just started practicing law, and it was $200 like all I had. I would be able to buy one Bitcoin at the time, so I decided to buy Dogecoin, and at its peak in
Mm.
2021 or whatever it was,
Mm.
2022, it was valued at about $25,000. So I
Mm.
turned like $25 into 25,000 before it tanked. And
Mm.
I finally, when it shot back up again, it didn't make it to 25,000. It made it to like about 12 or 13.
Mm.
And I sold it all and I just gave it to my mom, and she's in Spain right now using that money
Oh.
to travel.
Oh.
So
Oh, that's
it's
so good.
it's a win-win as long,
Yeah.
but it's a gamble, and you got to be very, very, very careful
Mm.
how you use that stuff.
Yeah. I do not give. It's the same with legal advice, financial advice, and so
Yeah, this is not
if
financial
if
advice.
if I knew what I was doing in the stock market, I would have a larger farm. Let's just say that. I'm just okay. I have some extra. I don't need it now. I'm not going to need it the next 10 years. Here's $500 into some index fund or something. And yeah, but I did buy silver, physical silver, like decade ago, and apparently that has gone up. But it's
Nice.
just it's in a drawer somewhere. But uh, the old as my dad said to me when I said, "Oh, look at this! I think I'm going to invest in it," and it just looked at me, "You?" And but he said, never invest never invest money you don't need. You won't need for at least, or to the translation is don't don't invest what you can't afford to lose.
Exactly. Exactly. And even when I was down, that 100K, thank God I was in a decent financial position that
Mm.
I could have lost it and I'd still be
Mm.
okay. I mean, don't get me wrong, it hurt. It hurt so much.
Mm.
Like physically hurt me because it feels like you lost a piece of you, a piece of yourself on a gamble. Nothing more than a gamble, something that you thought was just going to keep going up and up and up and up and up. And it didn't work that way, and I was very,
Mm.
very sad.
No.
But I can't tell you, in November when it all started coming back up and I was watching it like a hawk, like literally I couldn't take my eyes off my phone or my computer screen, seeing it. It's almost like I regained a piece of myself. I can't explain it. I
Mm.
cannot explain it in any way, shape, or form. I just felt like I became whole again. It was almost like somebody stole something from me and I was made whole again. So it was a really nice feeling. I'll just want to say that.
Mm. Yeah.
Yeah.
Yeah. Yeah. I can't say I ever had that kind of feeling, but say if something happens to the farm, I would be absolutely devastated. And about 20 years ago, I had to sell my house at a loss at that time. That it's not that it's something that went to, it's just that you invest more than money, you invest time.
No,
Oh wait.
I
Sorry,
gotta
Nick.
tell you about
Oh,
Sorry, I hate to cut you off, but I can't have both you and the hearing at the same time. So
Ah,
it
no
was
worries.
it was an
No worries.
absolute pleasure having you, Nick. I hate to cut this short, but we'll definitely do it again sometime.
We definitely have to. We definitely have to.
Love you, man.
You have fun with this hearing, and I will go back to preparing for tomorrow's negotiations.
Yes, sir. We'll see you soon.
See you soon.
Bye.
Bye, chat. Bye.
Thanks, Nick. Bye bye. All right. Here we go.
Lieutenant Fanning, we obviously
You were not,
recognize
just so we're clear, you were not told that by me.
that. No, we were told that by, and I'm getting to that as well.
There's another microphone in the
Told that
courtroom
by
now.
Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who
court
are in
officer-
charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on a reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required. Period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
And
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning. The
I
court
think it was Ms.
declined.
Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know. about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then
I remember
his name
that.
comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court.
That's just crazy.
It is not unreasonable to conclude that he was at least within the orbit
Yeah.
of the security operations
At least.
governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we'd have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Your Honor, the
Oh, whatever, Bev.
Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
Now
there
that you
evidence
know
that-
it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I take
So
the court
we
at its
will
word. But
move on from that, Mr. Jackson. We'll move on from that. So
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access even in the orbit of the jurors directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror? That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
All right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Wow, what a crap show. I mean, my God. Fanning had direct access to the jury, and Fanning is the one who got a juror removed? That is just ridiculous. That is absolutely ridiculous. Wow. By the way, the feed is okay, it went black for a second. This is insanity, folks. This is insanity. Fanning. Oops.
Thank you for that. The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sallyport issue, or the Sallyport video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of D.G.M. Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance, and that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built, and it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D. Jim Petro retired, we received four videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are four videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. One on October 10th, one on January 28th, 2020.
The volume is on maximum.
Then on Friday,
If you have volume issues, unfortunately, it's on your end.
something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. That means that the Massachusetts State Police not only had in their possession exterior Sally Port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024 because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through
now
my
or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January? How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all.
Stop rushing him.
That with the defense motion, which was supported by nearly 20 fact exhibits, there may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sally Port videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it? What page?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sally Port. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sally Port. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sally Port on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sally Port. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sally Port. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sally Port at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sally Port, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote-unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sally Port, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sally Port? How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error, and the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it, it's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that.
Yeah.
That's not what we should be doing in a trial for murder.
Yeah.
And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways.
Pick one.
They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. not one but two separate agencies, not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
Oh my God, Bev.
Cite them in my notes.
Why didn't you interrupt
If Ms. Little can get them
Brennan?
for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchanan. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly two in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications, or had daily communications, with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time, and it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us, and I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote-unquote defective.
Am I the only one who's getting a headache over this case? Because it's so blatant and so obvious I can't believe we actually have to hold a hearing over this.
Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably 45 minutes, I would say.
All right, so we'll break.
What? All rise, please.
All right. That was beautiful. But with absolutely no common sense, and for the court not giving a damn, maybe this is why I'm getting a headache. Much like a lot of you, I've personally been in Alan Jackson's shoes before, not in a murder case, of course, yet, but in my own cases, when you're trying to advocate for a client and you know before you open your mouth that for the next 60 minutes, 45 minutes, half an hour, however long you're going to be speaking for, every second that you are spending speaking about an issue, you know that the judge has already made up her mind or his mind, and they're going to deny your motion. Because I'm listening to this and I'm like, right, this is exactly what happened in the first trial. I'm listening to the evidence, the failure of the Commonwealth to turn over exculpatory evidence, the failure of them to turn over all of the video, for them to turn over inverted video. 9 points. Did you hear that from Alan Jackson today? 9 separate points. And each time, oh, Scrivener's error, our bad. The missing portions of the video. Things that could exonerate Karen Reed today, they failed to turn over. This case should have been dismissed before the first trial. It wasn't. Now it should be dismissed before the second trial, and we know that it won't. We know that Auntie Bev has already made up her mind. She knows how she's going to rule. She knows what her decision is going to be. We know what her decision is going to be. She's going to deny the motion. The trial moves forward. But Alan Jackson, God bless him, he's got nerves of steel. He has to protect the record, and he has to argue and state the facts to make sure that the court is aware. And I'm not talking about Auntie Bev's courtroom. I'm talking about the court upstairs, the Court of Appeals. Thank you, Beth Meadows, for being a member for 14 months. Welcome to the channel, or re-welcome to the channel. Her bias is unquestionable. It is open. It is direct. We've seen it. This is what it's like being in a relationship with a narcissist, which I have experience with. And if you don't have experience with it, God bless you. You're very lucky. No matter what you do, no matter what you say, no matter how you act, no matter how you try to criticize and say that you're uncomfortable with something, or they always have an answer. A narcissist will always have an answer. Well, it's actually not me, it's you. Or I actually didn't do anything. They'll fault you for your feelings. They'll fault you for your thoughts. They'll never say I'm sorry for their actions ever. And the same thing is going on in this courtroom. Judge Bev finds ways to. She interrupts Jackson's flow constantly. And believe you me, it's all intentional. It's all calculated. It's all subconscious. She's doing it because she's fed up with it. How long? She never asked Brennan, how long are you going to go, sir? Her tone is always softer with Brennan. She is much more relaxed when he is speaking. With Jackson, there's always this animosity. There's always this friction. There's constant. What page is that on? And where are you? And what are you talking about? And you can hear the undertones. It's the I don't care what you have to say. And it's atrocious. And I can't believe we're back here. Like, we're back to square one. We're going to have another trial. I am certain of it. And Karen is going to have to continue to suffer for another. Are we going to have 90 more witnesses for the government again, Brennan? Do we have the witness list? Are you going to call the entire family, extended family, boyfriends, girlfriends, fiancés? Are you going to call all their dogs back to the stand? I mean, I'm being facetious, but come on. I'm serious. Is this going to be a 100 witness trial again? 90 witnesses for the government, 10 for the defense, like it was last time? -2 probably for the ARCA witnesses are almost certainly going to get struck. It's the gift that keeps on giving that I want to stop from giving. And I know I'm not alone. Thank you, Mike Richard, for being a member for 9 months. He asks, can't they have Bev removed? Trust me, if they could have had her removed, she would have been removed by now. It's a small jurisdiction. It's probably a one-judge jurisdiction. They could bring out a judge from retirement, I'm sure. That's easy. But Bev is never going to recuse herself. She has her heels dug in. And what can we do? Asks the chat. What can we do? I wish I had an answer for you, chat. I wish I had an answer for you. This is by far one of the most bizarre cases I have ever reported on. Would I ever join the legal team? I don't think I would ever be invited, but sure. And somebody was asking who is the suited gentleman sitting behind Alan Jackson next to Karen Reed's mother. That's Betterow. He's another attorney. He's a local attorney in Massachusetts. He's been on the Young Jerks channel. He's been with Melanie Little. I've been on screen with him last year when the first trial was happening. He's a good dude. I really like his opinions. He's a very experienced and talented attorney. Mark Betterow. That's right. Mark. Is he New York? I thought he was Massachusetts. He might be New York. Really good guy. I really enjoy Mark Betterow's commentary. I don't think he has a channel of his own. Please correct me if I'm wrong, chat, but I'm pretty certain he usually appears as a guest on other people's channels. Excuse me. They're trying to get Mark on the case. That is awesome. That is awesome. I don't think there is anything that someone asked if Dershowitz showed up in a courtroom. Is Bev gonna pause? I don't think so. I don't think there is anything that could give Bev pause. Bev is just... She's just Bev. John Loomis says, Larry, I'm a former police officer from the UK. This situation could not and would not happen over here. It's a silly system you have over there. I don't disagree. The case would have already have been thrown out. And you know, in a lot of jurisdictions, if this case had been presented, it would have also already been thrown out. It's just that the police officers that covered up the murder or helped cover up the murder, they have been on notice that they're going to be able to skate by. And that's why this case has gotten as far as it has. Because I absolutely agree with you. This case would have been dismissed in many jurisdictions, even in the United States. Bev won't allow Betterow on the team. She doesn't have control. Well, hold on. Let me rephrase. Can he appear on the case in court and make arguments, etc.? Yes, she has control over that. She can deny him pro hac vici status, not for the state of Massachusetts, because he has to ask the Supreme Court for that. But yes, Auntie Bev could theoretically deny him from, you know, being like a fourth seat or whatever, unless he's going to replace Alessi or something. But there is nothing she can do to stop him from helping the team prepare the case behind the scenes. Nothing. They're going to get back at 2 o'clock. I need food and I need to get work done. My food is on the way. That's why I'm not rushing. I don't know if I'm going to have... Somebody said I'm an empath. I am an empath. I don't know if I'm going to have the energy for this or the time. My food's going to be here in about 10 minutes. So we have 10 minutes. What kind of questions do you guys have? Let's open it up to the chat. Let's open it up to you guys. I want to hear your thoughts on this. I mean, I think I already know. There's really, like, what do you ask? What do you ask at this point? What? You tell me. What kind of questions do you all have? What do you want to know? What do you want me to answer? As a practicing attorney, I know Turtle Boy's hearing is in about 45 minutes, 48 minutes. It's at 2 o'clock Eastern time. I'd love to cover. It's just I only have so much energy to go around. Yesterday and Monday were probably some of the busiest days I've had all year, and I'm not exaggerating. I was able to get so much stuff done, and I'm very excited for it. But I really want to continue covering this case, especially when the trial resumes. I'm certain that I'm going to have a lot to say the least. I'm going to have so much to say, you guys. And I'm here for it. I'm very excited for it. How's Chandler doing? Chandler's doing great. She's at work right now. Will Dr. Super Chadwolf be allowed to testify this time? Maybe. We don't know yet. We're waiting on Auntie Bev to rule. Will they try and go above the judge to get her removed? I don't know if they tried that yet. I think they tried it in the first trial. They failed. I doubt they're going to try it again. Do you think Bev's bias is something they can use in an appeal? 100%. How is presenting a case and the laws of physics prove? How is presenting a case that the laws of physics prove it's impossible not perpetrating a fraud on the court? It's a great question. The laws of physics don't apply in Bev's courtroom, I guess. Is it really impossible to get a corrupt judge taken off the case? It's possible, but it's very, very difficult. It's not impossible, but it's extremely difficult. How can Bev get away with the blatant disregard for this case? Exactly. Why is Jackson and not Yannetti arguing today? I don't know. I guess Jackson was assigned to this portion of the, they kind of split their motions amongst themselves, I guess. Alessi was arguing yesterday, I believe, and today on the motion to dismiss, it is Jackson's turn. Why does the police website have a .com instead of a .gov as an extension? It's a great question. Why is that? Is the Commonwealth going to call Proctor up and double embarrass? I'm waiting for that. That is one of the big moments that I'm waiting for. Because remember, Proctor has since been relieved of duties. He is done. He's no longer a Massachusetts trooper, Massachusetts State Police. So he is donezo. He can't wear a uniform in court. And of course, I've had this happen before. They're going to ask, one of the first questions, why aren't you in uniform? Well, I'm no longer on the force. They may not even call him, but they have to. He's the lead investigator. The courtroom's chat, the jury is going to be asking questions. Where's the lead investigator? Why aren't they testifying? Why is Bev allowed to be the judge in this trial after the obvious and egregious errors in not polling the jury, knowing that Reed was found not guilty on 2 of the charges? Why are all 3 charges still? These are all excellent questions. And corruption, it's just they're moving forward unabated, pretending like nothing happened and trying to pull a hat out of a rabbit. The government is. To try and get a conviction in a case where a conviction absolutely does not belong. Did you see Brennan tell Bev yesterday? So already I can say no. I only watched like 2 minutes of yesterday's hearing out of 4 hours. Did you see Brennan tell Bev yesterday AUSA told him the federal case was closed on February 19th, but didn't tell the defense until February 25th? Well, allegedly it's still open. because we have no proof. And until I see proof that it's been closed, I'm going to assume that it is open. Why do you think Bev sides with the prosecution 99.9% of the time? Because she's corrupt. She doesn't care about the defense. It can be taken to a higher court. Absolutely. The only chance Karen Reed has at this point is winning this case on appeal. If things continue as they are. I hate to say it, but it's true. With a judge like this. If she gets convicted, of course. I mean, if they acquit, I mean, that's the end of it. I can't wait for that interview. I should probably do a stream on that interview of the juror. Do you guys know what time the interview is premiering? I saw that it premieres today. I just didn't see a time. I think NBC 10 Boston is the one that is going to be releasing the video interview with the Karen Reed juror, the same juror that appeared on Turtle Boy's stream. I find it amazing that Turtle Boy was able to get him first, and then like 2 weeks later, the news picked him up. Now that I would definitely come back for. That I would come back for. I just don't know what time it premieres. Also, I'm still in the process, and I'm sorry for the delay, because this was filed last Sunday. It's been like 10 days ago. I want to do a video on the Jeremy Hales lawsuit against the 10 collective defendants for $9 million. That's on my to-do list. So be on the lookout for that. Oh my God, I'm so excited to make that video. Wait, the interview is already on YouTube, BC Natalie? Really? Thank you for letting me know. Let's watch it. She says there are clips. Wait. Where are the clips? No, 9 million, Sathanos. 3-minute part of the interview. Okay, well, I mean, still better than nothing. There's already 3-minute clips on YouTube if you want to watch. I just watched it. Boston 10 NBC. Okay, I'm on their YouTube channel. Is it under videos? There he is. Found it. Thank you.
We know this.
Here we go. Let's go ahead and get back into...
This case has caught the attention of people from New England and beyond. And tonight we are hearing from a juror from Reed's first trial.
And we should note that this is the first on-camera TV interview that any member of the jury has done. And he spoke with our Eli Rosenberg in a story that you will only see again right here on NBC 10 Boston.
Kind of overwhelming at first.
By the way, for the record, that's a lie. He appeared on Turtle Boy's channel. I'm 99.9% certain that's the same guy, but whatever. Go on. Lie to me more, news. Lie to me more.
And then it got very interesting, and then at the end, kind of disappointing.
You had this front row seat. What do people not understand?
It's difficult for some of the public to understand why we arrived somehow to our conclusion, but it was totally based on the evidence that was provided to us and that we could actually consider.
At the time, there were a couple things during the trial that were a huge deal as it happened on the outset. And I'm wondering, did it resonate with you? One being the testimony of Michael Proctor, the lead investigator, and those texts.
It was very surprising. It was very unprofessional. And at that point, most likely we would discredit or not consider his testimony as strong.
Another big thing was this Google search. How's long to die in the cold?
We didn't believe that there was enough evidence or expertise to kind of indicate that it was reliable. It did not appear, at least to myself, that she intended to commit murder. The other piece, which was the leaving a scene of an accident, also did not appear very clear, and therefore everybody voted for those two charges as not guilty. That second charge, that was the one that was very debated in terms of whether ultimately she did it, became questionable. And now that is where there was reasonable doubt in some minds. Unfortunately, we didn't get clarification early on that we could look at each charge individually and independently of each other. If we had done that, then I don't know where we would be or if we would be talking today.
Do you think there was going to ever be resolution on that second charge?
I honestly believe that there would not have been any resolution because some people had very good arguments, and at that point it was just trying to convince people and change people's beliefs, which would not be possible.
And this was interesting as well. After spending so much time together, the 9-week trial, the deliberations, eating lunch together every single day, this jury still talks all these months later. They have a group chat, they share texts, and Ronald says he will be watching some of Karen Read's second trial. He wishes those jurors all the luck. In Boston, Eli Rosenberg, NBC 10 Boston.
Huh. Amazing. Absolutely amazing. How do you acquit on 1 and 2, 1 and 3, and still be hung on 2? I thought the, 2 and 3 were related, or 1 and 2 were related. I need to see them. If I see them, it will be easier. But we didn't know. I mean, the magic words. We didn't know that we could have, no instruction was given to us that we could actually tell the judge, hey, we reached a partial decision, because there were no instructions given on partial decisions. And that's Auntie Bev's fault. That was her job. That was her duties. If she had provided the jurors with clear instructions, like, hey, by the way, you guys, do you have a verdict? Do you have like a unanimity? That's the magic word. Are you unanimous? Do you have unanimity on any of the charges? Oh, yes, Your Honor. We have unanimity on charges 1 and 3. Okay, fantastic. Let's go ahead and do that. Case resolved. Charge 2 moves on to trial number 2. But because of the judge's lack of desire for resolution of an acquittal, because she is dying for a conviction and she is willing to bend over backwards for it, now you're seeing the consequences of what happens when a judge has every intention to side with the prosecution every step of the way. We have, right now, every day in the Karen Read case, we have 4 prosecutors in that courtroom. We have, I forgot her name, not Linda, the female prosecutor. We have Lally. She the only reason I can't remember her name is because she rarely speaks. I do apologize. She almost never speaks. We have McLaughlin. She's a prosecutor. We have Lally. He's a prosecutor. We have Brennan. He's a prosecutor. And we have Beverly Cannoni. She's the 4th prosecutor in that courtroom. She's just wearing a robe. That's the only difference. I've seen it before. It's not that uncommon. We'll see. We'll continue paying attention to this case. We're going to continue covering it. We're going to continue following it. We're going to cover this trial, this case, these hearings. Like I said, today I'm probably going to conclude for the day. So I do apologize. I feel extremely drained. I've never felt this drained before after such a short period of time. It's almost as if I was up there arguing. That's how drained I feel. It's so weird. And then I will do a video. It won't be live. I will do a video on the $9 million lawsuit that Jeremy Hales filed against 10 different defendants, including B who shall not be named. That's a clever one. I just came up with that. B who shall not be named. You know who I'm talking about. BBB, some people call him. And David Helm from Lego Law, whatever he calls his channel. He changed his channel name so many times. He's named defendant. Lisa Weeks is a named defendant. John Cook, of course, and Lynette Alexis Michelle Preston. Those 5 I remember off the top of my head. And there are a few others in the ecosystem to destroy Jeremy. So I want to cover that filing, which was filed last Sunday. I still want to make a video. This one is probably going to be live. I just haven't had the emotional capacity to do it yet. But I want to do a video on my grandfather. He passed away on Christmas Day last year. And I have had the thumbnail for like 2.5 months now. Pretty much just a couple days after he passed, I was planning on doing a video on him just to talk about him, just to kind of memorialize him forever on the internet. And to get it off my chest so that people hear his story, because I'm the only one who can tell it, really, to an audience. So that is probably going to be live. I want it to be raw. It's going to be raw emotion. It's going to be raw stories, and I want to do it. I want to do that live. And then we'll make a few more videos. I know the hearing continues on Thursday, so I'm going to try and do that as well for Karen Reed. And I'm also going to try and do some more stuff as it comes up. All right, you guys. I love you all. Thank you all for being here. Thank you all for joining me. As always, I hope you learned something. I hope you enjoyed the show. Once again, I'm going to stop saying this soon, so I promise I will not beat this dead horse ad nauseum. Welcome to the new studio. And I'm still finishing tweaking some things here and there. I already saw I got an email about how to highlight comments on OBS while I'm live, so I'm going to review that and make sure that hopefully by the next stream that I'm live, I can highlight your comments. And I'm going to go eat. My food is probably almost here. I think it's here. Yep, my food's here. Perfect timing. Look at that. Couldn't have done it better. So until next time, folks, stay safe, stay true to each other, and I love you all. Bye, everybody.